Welcome back to one more session. Today in this video I am going to explain about crime. What is crime? Crime can be in simple terms we can say that an illegal act which amounts to a wrong against the public welfare. According to Blackstone, crime was defined as the breach and violation of public rights and duties which affect the whole community. In 1947, in a classical article, who is the criminal? In this article, which was uh, written by an American criminologist, Paul Tapan, he gave a definition to a crime. It's also known as a legalistic definition of crime. According to him, crime is an intentional act or omission in violation of criminal law, statutory or case law, committed without defense or excuse and penalized by the state. If you go through the definition, separate each of the components of the definition, crime is an intentional act. Crime is an intentional act. If you observe this statement, in the US and Indian system of law, there is a distinction between the mental element and the conduct element of crime. In order to secure conviction, the state must prove both beyond reasonable doubt. In Indian system of law, generally a mere act does not lead to liability unless that act is coupled with guilty mind. To understand that, I'll go through an example that X, let assume a person X may have harmed but may not be punished if X did not intend to cause the harm. This is about crime is an intentional act. So the intentional mind, the guilty mind is compulsory to establish the crime. And our omission, ordinarily if we do not do anything, we are not responsible, though generally we are not obliged to stop crime from being committed or not to help the victim in distress. Liability may be incurred for omission provided that there was a duty to act. In India, liability for omission to act and care generally follows from statutory legal instrument. For example, section 93 of the BNS 2023 declares, according to section 93 of the Bharatiya Nyaya Sanhita, it declares that exposure and abandonment of a child under 12 years of age by parent or person having care of it. They are how to take care of the child. Next, in violation of criminal law. In the definition, the next component is in violation of criminal law. In our system of law, before the state makes an arrest and try, there must be some specific law written in the criminal statutes. For example, BNS. In absent of that, it is not a crime. Strictly speaking, crimes are a product of criminal law. That is, unless something has been specifically declared as criminal, doing that thing would not lead to any liability. In that definition, the next component is statutory or case law. Statutory law is what is passed by the legislature, and case law stands for its judicial interpretation. Therefore, an idea of what is a crime would require knowing both the statutory and case law on the subject. The next component in the definition was committed without defense or excuse. Criminal law allows certain defenses and excuses, and if these are pleaded successfully, the alleged act, even if resulting in injury to the victim, would not be regarded as crime. These defenses or excuses are arguments that say that the person did not have a full mental element, or in some cases no mental element at all, to commit a crime. And the next component and last component in the definition is and penalized by the state. Punishment is the hallmark of a crime. In fact, it is the element of the punishment which goes on distinguish crimes from the other wrongs. Example, torts. An act is a crime if it is capable of being followed by criminal proceedings, having one of the types of outcomes, punishment, etc., known to follow these proceedings. In criminal proceedings, the state stands forward as a prosecutor on public policy grounds. This is a brief with respect to the crime. Thank you.